Caroline Norton's fingers trembled against her son's fevered brow as his chest drew one last, shallow breath. 2 years. For 2 full years, the law had forbidden her from seeing him. Now, in this humble servant's quarters, a refuge provided by compassionate staff, they were reunited. 9-year-old William, his body ravaged by illness, was dying in the embrace of a mother he no longer recognized. The summons had arrived that morning. Her youngest was gravely ill. She had rushed from her brother's residence, her heart pounding with every rotation of the carriage wheels. Yet the very legal system that had seized her children also dictated when she could visit them, even as they lay on the precipice of death. George Norton, her lawfully wedded husband, had only granted permission for this encounter once the physician confirmed it was too late. "Mama," William's voice was a mere breath. His eyes, clouded with fever, searched her face, devoid of recognition. She had missed 2 years of bedtime tales, of soothing his night terrors, of teaching him his alphabet. The law had decreed that her children belonged to their father with the same absolute ownership he held over his timepiece or his boots. She held him tighter, feeling the stillness creep into his small frame. There were no final declarations of love, no last moments of lucrative clarity, only the quiet fading of a life she had brought into existence but could not legally claim. Outside, church bells chimed the hour. Within, a mother discovered that British jurisprudence had devised the most cruel method of expunging a woman's very being, by permitting her to endure just long enough to witness the dissolution of all she held dear. But how had the legal framework of Britain transformed matrimony into a form of sanctioned homicide? And why did the simple utterance of "I do" signify the relinquishment of one's entire identity? To uncover the reasons, we must journey back to a time when brides walked down aisles unaware they were entering meticulously crafted snares, traps designed to shatter brilliant intellects, abscond with offspring, and inflict grievous bodily harm. The wedding night merely heralded the commencement of the torment. The pen slipped from her grasp at precisely 10:47 in the morning. Not because it was dropped, but because, in the eyes of the law, the hand that held it no longer possessed independent existence. Just yesterday, Miss Eleanora Peyton had affixed her signature to a contract for the acquisition of property in London. Her mark held authority, validated pacts, and facilitated monetary transactions. But this morning, as Mrs. Eleanor Fitzgerald, that identical signature held no consequence. The very church bells that celebrated her union also told for the demise of her legal persona. Herein lies the essence of Victorian marital statutes. They did not merely alter a woman's entitlements, they obliterated her existence entirely. Sir William Blackstone, whose legal treatises profoundly influenced British jurisprudence for generations, articulated it thus: by marriage, the husband and wife are one person in law. That is, the very being or legal existence of the woman is suspended during the marriage. Suspended, as if she had been hung in a forgotten closet, awaiting her husband's decision to retrieve her. Except he never would. For why would one revive someone whose very non-existence conferred absolute dominion? But the situation deteriorates further. This was not an antiquated legal quibble gathering dust in the archives of law libraries. This was coverture, the principle that subsumed a married woman's legal identity beneath that of her husband, much like casting a shroud over furnishings in an abandoned domicile. And it impacted every married woman in Britain, from the humble factory operative to the high-ranking duchess. The statistics are staggering. By the year 1851, over 3 million married women in England and Wales had effectively vanished into legal oblivion. They were incapable of possessing property, of executing contracts, or even of claiming ownership of the garments they wore. The instant they pledged their vows, all that they possessed, funds, estates, and even potential inheritances, automatically devolved to their husbands. Reflect upon this. A woman could inherit a considerable fortune on a Tuesday, enter into matrimony on a Wednesday, and find herself destitute by Thursday, not through expenditure or loss, but because the law declared she no longer existed as its proprietor. Francis Power Cobbe, who witnessed this phenomenon befall friend after friend, penned, "A woman's legal death by marriage is so complete that she cannot even claim her own earnings. A charwoman who labors 16 hours scrubbing floors, her wages belong entirely to her husband. He can collect them from her employer and squander them at the public house while she and her children starve." Now, recall, this was not enacted for the protection or provision of women. A husband bore no legal obligation to share even a fraction of his wife's prior assets with her. He could liquidate her inheritance, appropriate her wages, dispose of her possessions, and leave her utterly bereft. The legal designation was unity of person, yet unity implies the convergence of two distinct entities. This was, in reality, absorption, where one individual consumed another entirely, and the tribunals sanctioned this with zealous conviction. In 1865, when Mrs. Elizabeth Garrett Anderson attempted to register to vote by virtue of her property qualifications, the registrar merely chuckled. "But, madam," he explained as if addressing a child, "you do not exist." She countered that she paid taxes on that property. "Your husband pays taxes," he corrected. "The property is his. You are nothing." Nothing. That was the solitary word that reverberated through courtrooms and governmental offices whenever a married woman attempted to assert any form of entitlement. You possess nothing. You are entitled to nothing. In the estimation of the law, you are already deceased. But the true abomination was not what she forfeited. It was what he gained. A husband acquired not merely property rights. He gained dominion over a human being as thoroughly as if he had procured her at auction, and the law invariably supported him in every endeavor. Women who had established thriving businesses found themselves barred from their own establishments. Authors discovered their manuscripts now belonged to their husbands, to be published or destroyed at their whim. Artists witnessed their creations being sold without their consent, the proceeds disappearing into their husbands' coffers. Caroline Norton would later recount the agony of observing her own literary works, novels she had penned, poems she had meticulously crafted, being sold by her husband, while she herself struggled to afford sustenance. "I exist for the law only as his property," she stated. "I am his cattle to be utilized or discarded as he sees fit." And this was merely the initial phase of her obliteration. For while the forfeiture of one's legal existence was terrifying, await the revelation of what transpired when children entered the equation. The nursery door splintered under the bailiff's forceful impact. Within, 3 children cried out as strangers forcibly removed them from their beds. Caroline Norton reached the threshold just in time to see her youngest son, William's terror-stricken countenance vanish around the corridor's bend. "Mama!" The solitary word echoed down the desolate passageway. It would be 2 years before she heard his voice again, and by then it would be tragically too late. This was not a kidnapping in any criminal sense. This was the law operating precisely as it was conceived. George Norton had resolved to punish his wife for daring to abandon him following years of endured violence. His instrument of retribution was the Custody of Infants Act, which bestowed upon fathers absolute sovereignty over their children. Herein lies the critical flaw in Victorian custody legislation. Mothers possessed absolutely no rights whatsoever. None. A father could forcibly separate a nursing infant from its mother's breast and entrust it to the care of his paramour for upbringing. He could prohibit any form of interaction between mother and offspring. He could even deny a child nearing its demise the solace of its mother's presence. All of this was entirely lawful. Caroline's transgression. She had sought refuge at her brother's estate after George had rendered her unconscious with his blows. She had dared to seek protection from a man who had already fractured her ribs on 2 separate occasions. For this act of defiance, she would be made to pay with her children. The correspondence she exchanged during those 2 years of separation still exists. It reads like dispatches from a prisoner of war. "I implore you," one passage reads, "permit me to see them but once. Allow me to ascertain their well-being. William had a cough when you took them. Has it improved? Does Fletcher still recite his prayers? Has Brinsley learned to read?" Silence. George Norton did not even acknowledge her letters. According to the law, he was under no obligation to do so. The children were his possessions, as unequivocally as his furniture or his horses. A mother's affection, a child's yearning. These were sentimental considerations that the law chose to disregard, but the situation worsens. Caroline was not alone in her plight. Across Britain, countless mothers endure this very nightmare. Mrs. Elizabeth Ashton had not seen her daughters in 5 years, having fled her husband's alcoholism. Lady Rosina Bulwer-Lytton's children were raised to believe their mother was deceased, despite her residing mere miles away. The legal precedents established were profoundly chilling. In the case of Rex versus Greenhill, 1836, a father successfully pursued legal action against his wife's family for harboring his children, even though he had abandoned them and their mother was providing their sole support. The presiding judge ruled that the father's right was absolute and unassailable. Now, remember, these were not negligent fathers striving for custody out of paternal affection. In most instances, they sought their children as leverage. George Norton clearly articulated his intentions in a letter to Caroline's brother. "She may see the children when she returns to her proper place as my wife and submits to my authority. Not before." The message was unequivocally clear. Submit or forfeit your children permanently. This constituted a form of psychological coercion engineered to subjugate recalcitrant wives, and it proved effective. Numerous women returned to abusive husbands rather than face the complete loss of their children. However, some tragedies were beyond the scope of mere submission. In 1842, young William Norton contracted lockjaw. For days, he endured immense suffering while Caroline pleaded with George to allow her to be with him. Her letters became increasingly desperate. "He is dying. You know he is dying. Let me hold him. Let me say goodbye." George finally relented, but only after the physician confirmed that William had mere hours to live. Caroline rushed to the residence, but by the time she was admitted to that rear servant's chamber, her son barely recognized her. 2 years of enforced separation had not only stolen time, but also the very faculty of recognition. She would not know if he was even alive for another 2 years. During those intervening years, she had initiated a legal campaign to reform custody laws. She had authored pamphlets, lobbied Parliament, and collected testimonies from other mothers similarly bereaved, but the pace of change was too sluggish to rescue her own children. The judge who had affirmed George's custodial rights later offered a comment on the case that would forever haunt her. The law cannot bend to accommodate feminine sentiment. Order must be maintained. Order. That is what they termed the cries of children yearning for their mothers in the darkness of night. Order. That is what they labeled a dying child denied the comfort of his mother's presence. The law had devised a means to render maternal affection itself a criminal offense. But the confiscation of her children was merely preliminary. Next, they would seize something that seemed utterly impossible to purloin. Frances Power Cobb watched as her father's coffin was lowered into the earth, blissfully unaware that she was, in essence, burying her future alongside him. The reading of the will took place in her father's study, a space filled with the very books he had encouraged her to read, the desk where he had patiently taught her the art of writing. A sum of £20,000, a fortune that would have guaranteed her perpetual independence. Her father had dedicated years to amassing this inheritance for his intellectually gifted daughter. However, Frances had committed one critical error. She had married John Lambert 2 years prior, and under the prevailing laws of coverture, that inheritance might just as well have been cast into the ocean. Herein lies a fundamental tenet of Victorian property law. It extended not only to assets possessed by women at the time of their marriage, but was also retroactive and absolute. Any monetary funds, property, or inheritance that subsequently came into the possession of a married woman automatically became her husband's property in perpetuity. The morning following the will reading, Frances discovered the full implications of this decree. John had already visited her father's banker. The accounts had been summarily transferred. Her inheritance, every penny meticulously saved by her father through decades of prudent management, now resided entirely under her husband's sole discretion. "But surely," she protested to the family solicitor, "my father intended that money for me." The solicitor's sympathetic gaze conveyed the unfortunate reality. "The law is unequivocal, Mrs. Lambert. A married woman cannot own property. Your husband is being most generous in allowing you pin money." Pin money? A paltry sum here and there for ribbons and gloves, dispensed like tokens to a child. This from a fortune substantial enough to purchase a dwelling, finance a professional career, and secure a lifetime of financial autonomy. But the situation deteriorates further. John Lambert was not even considered a cruel husband by the prevailing Victorian standards. He simply perceived Frances's inheritance as his rightful due, a fortunate windfall to be invested in his flagging business ventures. When she implored him to set aside a portion for their future, he condescendingly patted her hand. "Do not trouble your mind with business matters, my dear. That is my domain." Within 18 months, the entire inheritance had evaporated. Ill-advised investments, speculative enterprises, and debts she remained utterly oblivious to until the bailiffs appeared. £20,000 vanished like morning mist, leaving Frances with absolutely no legal recourse whatsoever. She later penned, "To marry is for a woman to cast her property into the sea with the blind faith that her husband will dive down and retrieve it for her when needed. But what if he swims away instead?" Now, remember, this was not an anomaly. It was standard practice. Throughout Britain, women observed their inheritances dissipate into their husband's control. Mrs. Sarah Richardson inherited 3 houses from her aunt. Her husband promptly sold them all to settle his gambling debts. Miss Mary Ashford received a bequest of railway shares from her godmother. Her husband liquidated them within a month of their wedding. The legal mechanisms employed were remarkably efficient. A husband required neither his wife's signature nor even her awareness to dispose of her assets. Banks automatically transferred accounts upon presentation of proof of marriage. Property titles were re-registered without any consultation. Investment dividends were rerouted without prior notification. Occasionally, the newspapers documented the most egregious instances. In Birmingham, a woman who had inherited a prosperous millinery shop arrived one morning to discover that her husband had sold it overnight. In Manchester, a wife learned that her childhood residence had been mortgaged when creditors arrived to evict her. But the true cruelty resided in the smaller depredations. Wedding gifts from relatives were legally his. Jewelry passed down through generations became his to possess. Even the clothing women brought to the marriage union became their husband's property. One court case involved a husband who sold his wife's entire wardrobe, leaving her with nothing but the attire she wore. The judges upheld these entitlements without question. Lord Justice Fletcher, ruling on a case where a husband had sold his wife's inherited collection of books, declared, "The law cannot concern itself with domestic arrangements. What a husband does with his property is his business alone." His property, not their property, never her property. The possessive pronouns revealed the profound disparity in the law's perception of married women, relegating them to legal nonentities whose possessions, much like their very beings, simply ceased to exist. Some women attempted to circumvent these laws through the establishment of trusts and settlements. However, these measures necessitated costly legal counsel and the cooperation of male relatives. The majority of women possessed neither. They watched their economic futures vanish into their husbands' hands, utterly powerless to intervene. By sunset, 20 years of her father's savings had been squandered. Frances would spend the remainder of her life dependent on her husband's financial decisions, observing him fritter away the fortune her father had painstakingly accumulated over decades. If they could pilfer inherited wealth, imagine the fate of money that women earned through their own labor. Ellen Woodhouse's fingertips bled from 16-hour days spent meticulously stitching silk. Her husband's fingers bled from counting her profits at the gambling tables. For 5 years, Ellen had meticulously cultivated her dressmaking enterprise, stitch with careful precision. Beginning with a single sewing machine in their front parlor, she had expanded her operations to employ 20 seamstresses and had cultivated a clientele that included a significant portion of London's affluent ladies. Her shop on Bond Street showcased gowns that rivaled those produced in Paris. But herein lies a fundamental aspect of Victorian commercial law. A married woman could not legally possess a business. Every contract Ellen executed was rendered null and void. Every payment she collected automatically belonged to her husband. Every decision she made could be overridden by the man who had never so much as threaded a needle in his life. Thomas Woodhouse had devised the perfect stratagem. While Ellen toiled for 18 hours a day during the peak season, managing orders and training apprentices, he would personally collect her earnings directly from her clients. The account ledgers reflected weekly deposits amounting to hundreds of pounds, funds that never reached Ellen's hands. "I require fabric for the Countess's commission," Ellen would implore. "The girls need their wages." "Business is slow this month," Thomas would falsely claim, his breath reeking of gin. "Make do with what you have." Business was far from slow. Ellen's appointment book was overflowing with commissions, But Thomas's gambling debts escalated at an even more alarming rate. Every pound Ellen earned vanished into the bottomless abyss of his addiction. Meanwhile, she struggled to maintain the business's reputation with increasingly meager resources. But the situation worsens. When suppliers arrived to demand payment, they received no excuses. The law stipulated that Thomas Woodhouse owned the business, and therefore Thomas Woodhouse was accountable for its liabilities. Except Thomas harbored no intention of settling any accounts. Ellen watched in helpless despair as bailiffs catalogued her shop's inventory. 20 sewing machines were seized, bolts of silk and satin were confiscated, and even the partially completed gowns for her clients were claimed by creditors. 5 years of diligently building her empire had crumbled in a single morning. She had constructed an empire. He had discovered a gold mine, and the law ensured that the gold flowed exclusively in one direction. Now, remember, Ellen's predicament was far from unique. Across Britain, women's businesses served to subsidize their husbands' failures. Mrs. Catherine Morris managed a flourishing bakery that employed 8 individuals until her husband decided to invest its profits in a doomed mining venture. Mrs. Agnes Fletcher's successful boarding house provided financial stability for her family for years until her husband remortgaged it for a fraction of its true value. The pattern remained consistently the same. Women performed the labor, men claimed the profits, and when businesses faltered due to the husband's mismanagement, guess who bore the repercussions? The bankruptcy filings bore only one name. Whose name, do you suppose? But the disgrace, the ruined reputation, the lost livelihood. These burdens fell squarely upon Ellen. Her seamstresses, now unemployed, blamed her for their lost wages. Her clients, their orders unfulfilled, spread rumors that Mrs. Woodhouse could not be trusted. Thomas, meanwhile, faced no consequences. The law recognized him as the proprietor of the business, but when the enterprise failed, he simply shrugged. Women's work, he would remark to his drinking companions, too emotional for commerce. The irony was acutely painful. Ellen had masterfully managed inventory, shrewdly negotiated with suppliers, innovatively designed creations, and cultivated a loyal clientele through sheer talent and unwavering determination. Thomas's sole accomplishment was its complete ruination. Yet the law proclaimed him the natural custodian of business affairs. Some women attempted to shield their businesses through clandestine means. They operated under the names of male relatives, channeled profits through trusted friends, or dealt exclusively in cash that they could conceal. However, these strategies carried inherent risks. The discovery of hidden earnings could provide husbands with grounds to physically assault their wives for deception. The economic repercussions were staggering. Parliamentary reports from the 1850s estimated that married women's unpaid or misappropriated wages amounted to millions of pounds annually. This wealth, which could have elevated families from poverty, instead vanished into public houses and gambling dens. Ellen Woodhouse ultimately resorted to taking in piecework sewing, the very same labor she had performed before establishing her business. Yet now she found herself competing with her former employees for mere pennies per garment. Her husband continued to collect her meager earnings, persisted in squandering them, and still complained that she did not earn enough. She wrote to her sister, "I am Sisyphus in petticoats, forever pushing the boulder of his debts uphill, only to watch it roll down again. But unlike Sisyphus, I once stood at the summit. I know what I have lost." The summit, her shop, her independence, her life's work remained eternally beyond her reach. The law had made provisions for such matters, but the financial ruin a husband might face was minor compared to what the law explicitly permitted him to inflict next. The judge held his thumb up. "No thicker than this," he declared, as if measuring ingredients for a bake rather than implements for striking women. The judgment rendered by Lord Justice Buller in 1782 had become an unquestioned doctrine in Victorian courtrooms. A husband was legally permitted to chastise his wife with any switch no thicker than his thumb. This became known as the rule of thumb, effectively transforming domestic abuse into a matter of proper measurement rather than a criminal transgression. Hannah Mullen was seated in the witness enclosure, her left arm supported by a sling, her face still bearing the purple marks of contusions. After 5 years of escalating mistreatment, she had finally mustered the fortitude to bring charges against her husband. The evidence appeared irrefutable. Fractured ribs, a cracked skull, and the testimonies of neighbors who had heard screams in the darkness. However, the crucial aspect of Victorian domestic violence legislation, as it pertained to women, was its fundamental design. It was not intended for the protection of women. Instead, its purpose was to establish the acceptable limits of violence, and the threshold for what constituted excessive harm was virtually unattainable. The prosecuting counsel presented the medical findings: 3 fractured ribs, a concussion severe enough to cause temporary visual impairment, bite marks on her shoulders, and burns on her arms inflicted by a heated poker. A hush fell over the courtroom as each injury was meticulously detailed. Subsequently, the defense attorney rose. "My client readily admits to endeavoring to correct his wife's comportment, but he asserts the rod he utilized was clearly within the legally established parameters. As for the other afflictions, who can definitively ascertain how a woman of inherent clumsiness might sustain injuries around the household?" Clumsiness. Hannah had been a seamstress prior to her marriage, her fingers so nimble that she could thread a needle even in dim candlelight. Yet, paradoxically, her alleged clumsiness had somehow resulted in injuries consistent with systematic torture. The hospital report enumerated wounds that should have warranted charges of attempted murder. Dr. Matthews, who had attended to Hannah, testified, "In my 30 years of medical practice, I've seldom encountered such grievous injuries in a living patient. Another impact to her head would almost certainly have proven fatal. However, the situation is even more distressing." The judge appeared more preoccupied with Hannah's conduct than with the severity of her injuries. What had she done to merit such correction? Had she been compliant and respectful? Had she fulfilled her wifely obligations? Hannah's voice trembled as she responded. She had once overcooked their dinner, spoken sharply to him upon his return home inebriated, and failed to have his garments prepared one morning when he had given no prior indication of requiring them. Each perceived transgression was weighed against her injuries, as if to ascertain whether her bruises were proportionate to her supposed offenses. The jury deliberated for less than an hour, finding the husband guilty of assault, but with a significant provocation. The imposed penalty was a fortnight's incarceration and a £5 fine for nearly causing his wife's demise. Robert Mullins would serve less time than a petty thief. In lieu of further action, the judge offered Hannah a piece of advice. "Perhaps, Mrs. Mullins," he suggested, "you might take this period of your husband's brief absence to reflect upon more effective methods for fostering domestic tranquility. A judicious wife understands how to mollify her husband's temper rather than inflame it." It is important to remember that Hannah's case was exceptional only in its progression to the courtroom. The vast majority of domestic violence incidents never came to public attention. Women were acutely aware that initiating legal proceedings would result in public disgrace, victim blaming, and minimal repercussions for their assailants. When statistics were compiled at all, they revealed a grim reality. Hospital records from London indicated that 1 in every 4 women admitted for injuries had been subjected to violence by their husbands. However, police reports showed that fewer than 1 in 100 faced any charges. The legal system actively shielded abusive husbands. A woman who fled an abusive household could be forcibly returned. Law enforcement would drag her back to her husband as if she were a runaway slave. If she took her children, she could be accused of kidnapping. If she resisted, she faced assault charges far more severe than any her husband was likely to receive. Legal precedent after legal precedent upheld men's prerogative to discipline their wives. In the case of Queen vs. Jackson, decided in 1891, a husband who had confined his wife to their home initially received the court's support. It was only after widespread public outcry that a reversal occurred, and even then, the judge lamented the erosion of patriarchal authority. Frances Power Cobbe meticulously documented hundreds of such instances in her pamphlet, Wife Torture in England. She described women who had been blinded through acid attacks, women whose bones had been systematically broken over years, and women branded like cattle with hot irons. In virtually every instance, the husbands received minimal sentences or none at all, while the rule of thumb eventually fell into disuse as an explicit legal tenet. The underlying principle persisted. Violence within marriage was considered a private affair unless it escalated to extreme levels, with death being the apparent benchmark for too far. Anything less than murder was essentially viewed as excessive correction. Hannah Mullins returned to her husband following his 2-week sentence. What other recourse did she possess? She was unable to depart, unable to secure employment, and unable to safeguard herself. 6 months later, she was deceased. The coroner's verdict was accidental death. Her neighbors harbored a different understanding, yet the law had already rendered its judgment. If the courts sanctioned such violence, consider what the medical practitioners prescribed. The surgical instruments of Dr. Isaac Baker Brown clinked against the metal tray. His next patient was unaware that she would awaken from the procedure with her anatomy irrevocably altered. The young woman positioned on his operating table had been brought to him by her husband, accompanied by a list of disturbing symptoms. She read an excessive number of books, displayed a marked disinterest in domestic responsibilities, and, most troublingly, had expressed opinions on political matters. Dr. Brown had encountered this particular cluster of symptoms previously. His diagnosis was prompt: hysteria, attributed to excessive stimulation. His prescribed treatment was even more expeditious. The salient point regarding Victorian medical practices is that physicians did not merely treat the physical ailments of women, they actively enforced social conformity through surgical intervention. Dr. Isaac Baker Brown had perfected the ultimate instrument of enforcement: clitoridectomy, the surgical excision of the clitoris, employed as a remedy for defiant women. Between 1859 and 1866, Dr. Brown performed thousands of these procedures at his surgical establishment in London. His clientele included women whose perceived transgressions ranged from the enjoyment of novels to the refusal of marriage proposals. The commonality among them was their transgression of Victorian expectations of feminine behavior. Mrs. Elizabeth Ashford had been brought to Dr. Brown by her husband after she began attending suffrage meetings. "She has become excitable and argumentative," her husband explained, "and she neglects her duties." Dr. Brown nodded with understanding. He had witnessed this pattern of female dissent before and knew precisely how to address it. The surgery itself took less than an hour. No consent was required. Husbands were legally empowered to authorize any medical procedure for their wives. Elizabeth awoke from the operation mutilated, her body permanently disfigured without her knowledge or consent. The symptoms Dr. Brown claimed to cure shared a common thread. They all involved women engaging in independent thought or action. However, the situation deteriorates further. Dr. Brown proudly published his findings in medical journals, boasting of his success rates. Women who had been difficult became submissive. Those who had exhibited an interest in intellectual pursuits lost all inclination for learning. Women who had resisted their husbands' demands grew compliant. He interpreted this destruction of individual personality as definitive proof of his treatment's efficacy. His medical records revealed the true extent of the horror. Patient after patient was admitted for the offense of independence and discharged as mere shadows of their former selves. The entry for Mrs. R., aged 23, notes, "Brought by husband for excessive novel reading and neglect of needlework. Treatment successful. Patient now exhibits appropriate domestic focus." What he omitted was that Mrs. R. had been in the process of writing her own novel. She never penned another word. Upon awakening, something fundamental was absent, not merely physically, but psychologically. Women reported feeling detached from their own bodies, incapable of experiencing joy or pleasure in any form. The surgery did not merely remove tissue. It severed women's connection to their own humanity. It is crucial to understand that Dr. Brown was not an outlier practitioner. He held the esteemed position of President of the Medical Society of London and was a respected surgeon who trained other physicians in his techniques. His London surgical home was regarded as a premier institution for the treatment of recalcitrant women. The medical establishment largely endorsed his work. The Lancet published favorable reviews of his procedures, and other doctors referred patients to him. It was only when he began operating on women from affluent and influential families that questions began to surface, not concerning the ethics of mutilating women, but rather regarding the appropriateness of his patient selection. In 1867, Dr. Brown was ultimately expelled from the Obstetrical Society, not for the thousands of women he had mutilated, but for operating on a woman whose brother wielded significant political influence. The vote for expulsion was close, with 194 in favor and 38 against. A substantial third of his professional colleagues saw no ethical issue with his practices. Yet the damage was already inflicted. Thousands of women across Great Britain lived with the enduring consequences of his surgical interventions. Many never fully comprehended the extent of what had been done to them. Their husbands and physicians collaborated to maintain their ignorance. All they knew was that they had been fundamentally altered, their bodies reshaped to enforce their submission. Other forms of medical coercion were equally appalling. Physicians prescribed lengthy courses of pelvic massage intended to break women's spirits. They cauterized services to quell female arousal. Ovaries were removed to address ailments ranging from epilepsy to disagreements with husbands. The medical justifications consistently centered on women's supposed inherent mental frailty. Strong emotions, intellectual engagement, or physical exertion could apparently precipitate a descent into hysteria. The prescribed remedy remained constant: remove or destroy any part of a woman's anatomy that afforded her autonomy or pleasure. Dr. Brown continued his private practice following his expulsion, shielded by grateful husbands who valued his services. He passed away peacefully in 1873, never facing legal accountability for his transgressions. His victims endured, physically altered and silenced, enduring testaments to the Victorian medical perspective that viewed female independence as a curable affliction to be eradicated by any means necessary. While physical mutilation was horrific, the asylum system offered a fate arguably worse: internment akin to being buried alive. Lady Rosina Bulwer-Lytton's transgression. She had found her husband's novels tedious. Her sentence, indefinite confinement within an institution for the mentally ill, the morning of June 23, 1858, dawned like any other for Lady Rosina. She was preparing for a journey to London when 3 men appeared at her door. A physician she had never encountered, a barrister unknown to her, and a magistrate who declined to elucidate his purpose. Within the span of an hour, she found herself en route to White House, a private asylum catering to women deemed problematic. The critical element of Victorian asylum law was that the commitment of a wife required the signatures of only 2 doctors, neither of whom was obligated to examine her. A husband's assertion that his wife was excitable or unmanageable was sufficient grounds for a diagnosis of insanity. Once admitted to an asylum, women possessed no legal recourse for their release. Edward Bulwer-Lytton, a celebrated novelist and politician, had discovered the ideal resolution to his marital discord. Divorce would undoubtedly invite scandal, and murder carried unacceptable risks. However, having his wife declared insane was perfectly legal and socially acceptable. Rosina's actual offenses were unpardonable by Victorian standards. She had publicly critiqued her husband's literary works. More damningly, she had authored her own novels, which exposed his cruelty. When he curtailed her financial allowance, she had the audacity to petition Parliament for assistance. Such behavior, unequivocally, pointed to a diseased mind, at least according to the physicians Edward had retained. The asylum director had not even examined her. It was unnecessary. The commitment papers were in order, the fees had been paid, and Mrs. Bulwer-Lytton was now under his care, irrespective of her actual mental state. Her protests only served to corroborate her diagnosis. What sane woman would contend that her esteemed husband was persecuting her? However, the situation becomes even more dire. Within the confines of White House, Rosina discovered dozens of other wives who had become inconvenient. Mrs. Catherine Weldon had been committed for refusing to relinquish her inheritance. Mrs. Mary Ashton was declared insane after discovering her husband with his mistress. Mrs. Eleanor Bright's offense was requesting a separation after enduring years of physical abuse. None of these women suffered from any recognized form of insanity. They were merely obstacles to their husbands' desires, removed as efficiently as unwanted furnishings. The asylum system had effectively transformed into a private network of correctional facilities for disobedient wives. Multiple physicians subsequently examined her and declared her sane, but their opinions held no legal sway. Only the physicians who had committed her, compensated by her husband, possessed the authority to authorize her release. This constituted an inescapable predicament. The same financial incentives that facilitated women's admission to asylums ensured their indefinite confinement. It is essential to recall that private madhouses operated as businesses, with each patient representing a consistent revenue stream from their families. Why would an institution release a profitable patient if her husband continued to remit payment promptly for her ongoing incarceration? Some women spent decades within asylums, their sanity intact, but their freedom irrevocably lost. The alleged Lunatics' Friends Society, established in 1845, attempted to investigate these abuses. Their records revealed hundreds of analogous cases. Women confined for reading inappropriate books, for expressing political viewpoints, or simply for causing annoyance to their husbands. However, the society faced an arduous struggle against a system deliberately designed to silence women. The conditions within these institutions ranged from genteel imprisonment to outright torture. White House, while restrictive, offered relatively comfortable accommodations. Rosina had a private room and was permitted to write letters, albeit subject to censorship. Other establishments employed hydrotherapy, physical restraints, and solitary confinement as methods to break women's resolve. The objective was not rehabilitation, but subjugation. Rosina's situation only escalated into a public scandal due to the intervention of influential friends. The writer, Charles Reade, initiated a public campaign advocating for her release. Newspapers seized upon the story, and questions were raised in Parliament. After a mere 3 weeks, Edward was compelled to release her, not because her sanity had been restored, but because the ensuing publicity posed a threat to his political career. The Society's case files documented hundreds of similar situations. In Manchester, they discovered a woman who had been confined for a decade for excessive charitable activities. In Birmingham, a wife had been incarcerated for refusing to entertain her husband's mistress. Each file presented a consistent narrative: sane women buried alive in mental institutions for the offense of inconveniencing men. Yet the majority of women lacked such fortunate circumstances. Without influential connections or public attention, they remained imprisoned. Some succumbed to despair and genuinely deteriorated from the effects of confinement. Others learned to feign sanity according to the standards of their captors, becoming silent, obedient, and broken. The asylum system ultimately illustrated the fundamental logic underpinning Victorian marital law. If wives were considered property, then malfunctioning property could be stored until it learned to comply. The mere threat of such confinement served as a deterrent for many women. Husbands would often admonish their wives, "Be careful, or you will end up like poor Mrs. So-and-so in the asylum." Those who managed to escape the asylum faced a different form of lifelong sentence, one measured in pregnancies. Every working-class woman understood the inherent risks. The analogy was akin to spinning a revolver cylinder 30 times, with the expectation that one chamber would contain a bullet. For these women, the equivalent was a pregnancy. Mary Thompson had already spun that chamber 14 times, 14 pregnancies within 16 years of marriage, resulting in 10 living children and 4 small graves in the churchyard. Now, as she felt the familiar signs of a 15th pregnancy, she comprehended the grim arithmetic of her own likely demise. The perilous reality of Victorian childbirth was not merely inherent danger, it was deliberately exacerbated by the legal framework. Women possessed no legal right to refuse their husbands' sexual advances, had no access to contraception, and were left with no alternative but to engage in reproductive Russian roulette until their bodies failed. For working-class women like Mary, the odds were unforgiving. 1 in 30 would succumb to childbirth or its immediate complications. Each pregnancy represented another pull of the trigger, another opportunity for hemorrhage, infection, or sheer exhaustion to claim them. and they were compelled to continue this cycle as long as their husbands demanded it. Dr. William Farr, a meticulous compiler of medical statistics, documented this devastating toll in his 1876 report. In the most impoverished sectors of Manchester, maternal mortality rates reached 1 in 25. In the squalid districts of East London, this figure climbed to 1 in 20. These were not mere statistics. They were death sentences inscribed upon women's bodies. However, the situation deteriorates further. The affluent possessed avenues of escape unavailable to the poor. Wealthy women employed wet nurses, thus avoiding the physical strain of breastfeeding. They could afford anesthetics like chloroform for pain relief, sterile bedding to prevent infections, and, crucially, physicians who were more likely to adhere to hygienic practices. Mary Thompson spun the chamber 14 times. The 15th pregnancy proved fatal. She suffered a post-delivery hemorrhage, bleeding out while the local midwife made a desperate attempt to save her. Her husband remarried within 3 months, needing someone to care for the 10 children Mary had left behind. It is important to recall that these fatalities were entirely preventable. Physicians were aware of antiseptic techniques by the 1860s and understood the risks associated with overly frequent pregnancies. Nevertheless, the law granted husbands absolute dominion over their wives' bodies, and the majority of men viewed large families as a testament to their virility, irrespective of the cost in women's lives. The disparity in maternal mortality rates between social classes was stark. Women of higher social standing faced odds of 1 in 200, still a significant risk, but one with a greater probability of survival. They had the means to space pregnancies, rest between births, and hire assistance for their other children. Their bodies were not depleted by strenuous labor and malnutrition before confronting the challenges of childbirth. Her husband remarried within 3 months, not necessarily out of callousness, but out of practical necessity. 10 children required care, and the law presumed that another woman would readily assume Mary's role. Her replacement would face the identical reproductive gamble, the same inexorable arithmetic of mortality. Working-class women resorted to desperate measures to evade pregnancy. They consumed pennyroyal tea, aware of its potential toxicity. They engaged in strenuous physical activity, hoping to induce miscarriage. They sought out hazardous back-alley procedures, which proved fatal as often as they prevented conception. The law condemned these attempts as criminal, while the women themselves viewed them as acts of survival. Testimonies gathered by early social reformers illuminate this desperation. "I have buried 3 sisters due to childbirth," one woman wrote. "Now it is my turn," stated another. 16 times I've endured this. I pray each time will be the last." Furthermore, even discussing family limitation was perilous. The Obscene Publications Act of 1857 rendered the dissemination of contraceptive information illegal. Annie Besant was prosecuted in 1877 merely for publishing a pamphlet on family planning. The message was unequivocal. Women's bodies were intended for procreation, and the law would ensure they continued to procreate until they perished. Some physicians endeavored to offer assistance. Dr. Elizabeth Blackwell discreetly advised women on spacing their pregnancies. Dr. Elizabeth Garrett Anderson suggested medical reasons for sexual abstinence when she encountered exhausted mothers on the verge of collapse. However, such counsel placed their medical licenses at considerable risk. The psychological burden mirrored the physical toll. Women lived in a state of perpetual apprehension, not only of death, but also of leaving their existing children orphaned. They witnessed friends and neighbors succumb to childbirth, knowing their own turn might arrive with the next pregnancy. Some deliberately avoided their husbands, opting to sleep in their children's rooms or feigning illness. However, the law supported husbands who insisted on their conjugal rights. A wife who refused could face divorce on grounds of desertion, forfeiting her children, her home, and her entire existence. Consequently, women submitted, spinning that chamber repeatedly until their luck ran out. By 1890, maternal mortality had become a national disgrace. Reformers urgently demanded legislative change, highlighting that Britain was inflicting fatalities upon its mothers at rates that appalled even the most conservative politicians. Nevertheless, progress was slow, and for women like Mary Thompson, it arrived far too late. Her 10 children grew up without a mother. The elder daughters were compelled into service, assuming the responsibility of raising their younger siblings. It was a familiar scene in countless working-class households. Women succumbing during childbirth, their daughters forced to abandon their own aspirations to fill the void. This grim cycle persisted until a courageous soul broke free or was utterly crushed by its weight. Yet, some expectant mothers endured perils so profound that even a fatal labor would seem a gentler fate. The sheer volume of coal dust encrusting Sarah's pregnant abdomen was so considerable that the mine inspector failed to register her 9-month gestation until she faltered and collapsed midway down the passage. For 12 agonizing hours each day, Sarah Richards would crawl through tunnels no taller than 3 feet, hauling loads of coal weighing 100 pounds. The coarse leather harness dug into her swollen breasts. The chain positioned between her legs rubbed raw against her thighs, and deep within her womb, the infant destined to be born into shadow, kicked against the burden of the coal cart. The unfortunate reality of Victorian labor regulations was their profound inadequacy. They offered greater protection to horses than to pregnant women. Pit ponies were afforded regulated work schedules and mandatory rest periods, privileges denied to women. These women toiled until labor commenced, occasionally giving birth within the very tunnels where they excavated coal. In 1842, the Parliamentary Commission dispatched investigators into Britain's mines. Their findings proved so shocking they unsettled even the most seasoned politicians. Women and young girls, some as young as 6 years old, labored under conditions that would have been deemed illegal for animals. However, it was the plight of the expectant mothers that evoked the deepest horror. Sarah's experience was far from unique. Married at 16 to a miner, she found herself pregnant by 17. She joined him in the mine's depths because his earnings alone were insufficient to sustain their burgeoning family. Mine owners consistently paid women half the wages they afforded men. Yet, within the harsh economic realities of Victorian poverty, even these meager sums represented the difference between survival and utter destitution. The situation, however, deteriorated further. The pervasive darkness within the mines was not merely physical, it was deeply ingrained in the legal framework. These women were effectively invisible to any system designed for worker protection. They were barred from union membership, unable to provide testimony regarding their working conditions, and legally denied the right to claim their own wages, as their husbands routinely collected their earnings directly from the mine offices. Sarah had already experienced childbirth within that same tunnel on 2 previous occasions. The first time, labor had begun unexpectedly, and she was entirely alone. She delivered her son by touch in absolute darkness, severing the umbilical cord herself with her teeth before laboriously crawling back to the surface, with her newborn swaddled against her chest. Tragically, the infant survived for only 3 days. It is crucial to understand that these circumstances were not exceptional. The 1842 report documented the labor of hundreds of pregnant women working underground across Britain. In certain mining districts, their numbers surpassed those of the men. Their bodies bore undeniable testimony to their ordeal. Spines contorted from crawling, skin perpetually stained with black, and lungs scarred by the omnipresent coal dust. Betty Harris, then 37 years of age, provided testimony to the commission, stating, "I have a belt around my waist and a chain passing between my legs, and I go on my hands and feet. The road is very steep, and we have to hold by a rope. I have drawn till I have had the skin off me. The belt and chain is worse when we are in the family way." The phrase, "when we are in the family way," haunted the commissioners, suggesting pregnancy was merely another occupational hazard, akin to adverse weather or a particularly challenging coal seam. These women recounted the experience of carrying children within them while simultaneously bearing the weight of coal upon their backs, with a remarkable, almost dispassionate tone. The inspector's report acknowledged their situation as regrettable, but deemed it necessary. The mine owners asserted that any reduction in women's labor would inevitably lead to increased coal prices. The nation's economy, they argued, depended on pregnant women navigating the subterranean darkness, their unborn children inhaling coal dust with every breath their mothers took. Some women attempted to conceal their pregnancies by tightly binding their abdomens to prolong their working capacity. Others continued laboring until the onset of childbirth, delivering their babies in the mine shafts before returning to work mere days later. They possessed no alternative. A single day's lost wages meant their families would go without sustenance. The Mines Act of 1842 eventually prohibited women from working underground. However, this victory proved hollow. The loss of underground wages plunged mining families into the abyss of starvation. Women were consequently relegated to surface work, where they sorted coal in all climatic conditions, shattered rocks with heavy hammers, and propelled loaded carts up steep inclines. Still pregnant, still engaged in arduous labor, they were now visible, though their suffering continued. Sarah Richards gave birth to her third child merely 2 days after the inspector discovered her collapsed state. The infant girl was born small and struggled to draw breath, her lungs already compromised by months of exposure to coal dust. She survived for a mere 6 weeks. Sarah returned to work within days of her daughter's burial. Although no longer working underground, she toiled at the pit head, breaking coal, her body still bearing the physical trauma of childbirth. The omnipresent darkness pursued these women even into the light of day. The inhaled coal dust led to persistent coughing, while damaged spines resulted in chronic pain. Always present was the grim certainty that their daughters would likely face the identical fate. Early marriages to miners, repeated pregnancies, and bodies ravaged by both reproductive and industrial labor were the recurring narratives. The Commission's report ignited public outrage, but societal change unfolded at a glacial pace. For women like Sarah, survival necessitated a choice between differing forms of darkness, the literal gloom of the mines or the economic despair of poverty. In either scenario, they navigated their pregnancies and labors, both physical and metaphorical, through sheer endurance. For those who weathered these immense hardships, freedom theoretically existed. However, this freedom came at a prohibitive cost. 5 years of wages amounting to £600. Margaret painstakingly recounted the coins, realizing she still required 4 more years and £400 before she could legally extricate herself from her abusive husband. The Matrimonial Causes Act of 1857 had finally rendered divorce legally attainable for ordinary citizens. Yet a significant impediment remained: its prohibitive cost. The cumulative expenses, encompassing court fees, legal representation, and mandatory procedural costs, range from £500 to £1,000. For a working woman earning a mere £10 annually, this sum was effectively insurmountable, akin to £1 million. The fundamental flaw of Victorian divorce law was its deliberate design. It was not conceived to liberate abused women, but rather to create the illusion of possibility while perpetually withholding genuine freedom. The law mandated that women prove not only adultery, but also adultery coupled with desertion, bigamy, rape, sodomy, bestiality, or extreme cruelty. Conversely, men were only required to establish simple adultery. Margaret Henderson possessed evidence of all these transgressions. Her husband's mistress resided openly within their home. He had repeatedly beaten Margaret into unconsciousness and infected her with syphilis through his illicit encounters with prostitutes. By any reasonable measure, she qualified for a divorce. Her only obstacle was the accumulation of £500. For 3 years, she meticulously skimmed pennies from the household funds, secreted coins in ceramic jars, and undertook clandestine sewing work, concealing her earnings within her shoes. Each saved penny represented a sacrifice in another area of their lives. Vital medicine for sick children, fuel for winter heating, and at times, even sustenance. The situation, however, worsened. One December morning, her husband discovered her hidden savings, £400 concealed within a tea caddy, tucked behind loose bricks in the cellar. This fund, painstakingly amassed over 3 years of hardship, represented her potential escape. Without a word, he appropriated the money. She had toiled for 3 years, only for him to discover and seize her hidden wealth. This discovery was not accidental. He had actively searched for her savings. Margaret later learned that he had suspected her intentions and systematically sought out her accumulated funds. The law that declared her his property also rendered her escape fund his to steal. A pawnbroker recognized the wedding ring. It was the 5th such item he had encountered that week. Desperate women were flooding pawn shops with their wedding rings in a futile attempt to raise divorce fees. However, even a gold band yielded only a few pounds, a minuscule contribution towards the hundreds required for legal liberation. It is important to recall that even if women managed to amass the necessary funds, the court proceedings themselves were deliberately designed to be humiliating. Divorce cases were conducted in open court, with newspaper reporters in attendance. Every intimate detail of abuse, every instance of sexual degradation, and every private humiliation became public spectacle. Divorce court records from 1858 to 1870 clearly illustrate this pattern. Out of 3,000 petitions filed, fewer than 300 originated from women. Of these, a mere 127 were successful. The vast majority failed due to technicalities, insufficient evidence, or the judge's disbelief of women's testimony against their husbands. Mrs. Anna Sewell painstakingly saved for 7 years before initiating divorce proceedings. She had witnesses to her husband's adultery, medical proof of his violence, and evidence of him infecting her with a venereal disease. Despite this, the judge dismissed her petition, citing her continued cohabitation with him. What alternative did she possess? This ruling implicitly condemned her behavior. Some women discovered alternative avenues to freedom. Immigration societies assisted women in relocating to the colonies. Charitable organizations occasionally bore the divorce costs for the most desperate cases. However, for every woman who managed to escape, hundreds remained ensnared. The true cost extended beyond financial considerations. Divorced women forfeited everything: their children, their homes, and their social standing. They became pariahs, deemed unmarriageable and often unemployable. Hotels refused them accommodation, and respectable boarding houses turned them away. They exchanged one form of social death for another. Margaret never managed to save enough for a divorce, but she found a different exit. One night, following a particularly brutal assault, she did not rise. The coroner attributed her death to natural causes, citing a weak heart. Her neighbors, however, knew the truth. She had simply decided that death was a more affordable option than divorce. Her story was mirrored across Britain. Women chose the river as an escape from ongoing marriages, ingested poison rather than face another pregnancy, or simply wasted away, refusing nourishment and medical attention until their bodies succumbed. When death presented as the only attainable escape, some embraced it. Reformers diligently collected these harrowing accounts, steadily increasing pressure for change. Yet, progress was agonizingly slow. The Married Women's Property Acts of 1870 and 1882 granted women some dominion over their earnings. The Matrimonial Causes Act of 1878 empowered magistrates to issue separation orders. These were small victories, each purchased with women's tears and paid for with children's lives. The legal system that had, with callous indifference, contributed to William Norton's demise, gradually and reluctantly began to acknowledge women as human beings rather than mere property. However, Caroline never truly recovered from that somber September morning. She observed mourning for the remainder of her life, not only for William but for all the lost moments and unshared years, for the relationship that the law had as effectively murdered as disease had claimed his body. Her words resonate through history. I exist in law only as another man's property. The children I bore in pain and raised in love belong to him absolutely. The law has made me a ghost in my own life, haunting the edges of what should have been mine. The spectral legacy of Victorian marriage law, Caroline Norton cradling her dying son, Ellen Woodhouse witnessing her livelihood crumble, Sarah Richards laboring through mine shafts while pregnant. All these women, interred alive in asylums or legally beaten to death, deserve to be remembered, not as passive victims, but as potent warnings. The true horrors of the wedding night were not confined to the bedroom. They resided within the legal texts penned by men who believed a woman's existence ceased upon marriage. Some of these deeply ingrained beliefs proved more resilient than William Norton himself. Some persist to this day. Francis Wright, the Scottish reformer, eloquently captured this sentiment. I would rather be a free spinster and paddle my own canoe than be the slave wife of any man on earth. The cost of that servitude was measured in women's physical well-being, their mental fortitude, and their very lives. Never forget. Never revert. Never permit the law to be wielded as a weapon against half of humanity again. The church bells that tolled for Victorian weddings were, in essence, also funeral bells.